Hello, this is attorney Tara Hutchinson with Pittsburgh Family Law Services, where I provide you with brief, helpful information about Pennsylvania family law and estate planning matters. Today, we're going to talk about how to represent yourself as a defendant in a protection from abuse, or PFA for short, matter. So I'm going to save this for the end about why you may be considering representing yourself, or if you're just curious about why somebody would choose to represent themselves in this, but I'll save that for the very end. When it comes to representing yourself in a PFA as a defendant, your representation of yourself starts from the moment that you get served with that temporary order. So when you are served with the PFA, the police will serve you, or the sheriff will serve you. You will know that you've been served with the PFA. When you get that temporary order, you are required to leave the residence immediately. Well, really, you are evicted from the plaintiff's residence. Very often, this is also your residence. That means you are to gather your belongings, you are to do that immediately, and you are to leave. So take whatever, there is no time to arrange for movers. You're not going to get a moving truck out there in an hour or less to get all of your belongings. So you are to take what you can, and you leave. And the order is not going to say where you can go. The law doesn't really care about where you go. So you go to a friend's, you stay with friends, you stay with family. If there are no other options, you stay in a hotel. The order says you are evicted from the residence. That is what you are to do. You must leave, and you must leave immediately. This is not in any way optional. It's also important that when you're doing this, when you are served with the temporary order, that you resist the urge to show very strong emotional reactions. If you're not expecting to be served with a PFA, and let's face it, most people are not expecting it, this comes as a shock. But I strongly encourage you to resist the urge to yell at the police officers, or to say that this is fake, or that you didn't do anything, or that it's unfair. Resist the urge to do that. This is not a hearing. You will have an opportunity to present your defense, but it's not going to occur the day that you get served with the order. If you are calm, if you are respectful, then if you do have to go back to the residence because you forgot, like let's say you forgot to take a medication because you were in such shock with being served and having to leave immediately that it just completely slipped your mind, the sheriff's department or the police department, they are far more likely to assist you and work with you to get back to the house at an appropriate time with supervision and an escort if you didn't react in a very angry manner. And I'm not saying you can't be upset, but I'm saying to be mindful of how you are interacting with the person who served you with the temporary order. When you get the temporary order, make sure that you read it, and that you read it carefully. So again, you have to relinquish your firearms. If you own firearms, you are required to turn them over. That is written into the order. This is not optional. Also, no contact means absolutely no contact. No phone calls, no text messages, no Facebook messages, no sending flowers. If you see the plaintiff walking down the street, you turn away. You do not approach the plaintiff. You do not visit the plaintiff. You do not answer the plaintiff, even if the plaintiff sends you a text message and says, can we just talk about this? Do not interact with the plaintiff in any way. Again, that is written in the order. Same thing if your children are considered protected parties under that order, and the order says no contact with the children. You're probably going to guess what I'm going to say next. No contact means no contact at all. But again, read the order. So many PFA defendants get to the hearing and they find themselves already in trouble because they were so shocked after they received the temporary PFA order that they didn't sit down and take the time to read it and understand what their obligations actually were. Now, I'm not saying that if you get served with a PFA and the plaintiff sends you a text message and you respond to it, I'm not saying that you can't ultimately resolve that issue at the hearing, but you already start out in a worse spot because you've already violated the order once, and that just makes it harder to resolve the PFA at the final hearing. So my first two big tips are be mindful of how you are interacting with the person who serves you, and secondly, read the temporary order very, very carefully. The other thing to keep in mind if you are representing yourself is that when you go to the hearing, when you go to the final PFA hearing, the plaintiff will most likely be represented by somebody from legal aid or by a volunteer attorney. 9 times out of 10, PFA matters actually end up being resolved without ever going to a hearing. And this is a good thing. It's certainly a good thing for PFA defendants, but you want to be very mindful of the fact that the attorney who is approaching you and saying, can we work this out? Can we resolve it? That attorney does not represent you. That attorney is not a neutral party. The attorney's job, whether they're being paid for it or not, the attorney's job is just to represent the plaintiff. So sometimes what happens, or I should actually say often what happens, is the attorney representing the plaintiff will approach the defendant who's unrepresented, and they will tell the defendant, here's a way, we want to resolve this. We don't want to go to a hearing. The plaintiff doesn't think that a hearing is really going to benefit anybody. How does that sound? And the defendant says, yes, that sounds great. Okay, here's an order that I've typed up that I'd like you to read and sign. And the defendant just signs it quickly to get done and get out of there as quickly as possible so that they can go back to work. And the defendant hasn't even read it carefully enough to understand that what they have just signed is a final order consenting to the entry of a PFA against them. So the plaintiff's attorney is not your friend. The plaintiff's attorney is not your attorney. So if you are handed with an order, make sure that you absolutely understand what exactly it is that you are consenting to. Make sure you know whether you are being asked to consent to a final PFA. I will say as a practice point, and if you're waiting in a large waiting area and you hear other PFA defendants talking with their attorneys, you may actually hear this come up. there are some attorneys who will take the position of, if you've done something that really falls under the heading of a PFA, that definitely you're at definite risk of having a final PFA found against you if this goes to a hearing. Some attorneys will encourage their clients to consent to a PFA because it may be for a shorter duration than if they went to a hearing and the judge has to make that decision. There are definitely a lot of attorneys who take that position and who advise their clients accordingly. And there have been times where I have done that with my own clients. My attitude toward that, though, is functionally the only difference between a 6-month PFA and a 3-year PFA, which is the maximum. The only functional difference between those two is the amount of time that it's in place. Whether it's 6 months, whether it's 36 months, it does not change the fact that now you have a final PFA that you will have to disclose in the future. So in general, what I do these days as a general practice point, I will often advise my clients, be careful about consenting to any type of PFA, and if we're really serious about taking a position that what happened does not fall under the statute, under the PFA Act, if we're really confident that it shouldn't meet the definition of abuse, then you're better off going to a hearing, because if you consent to it, you will definitely get a final PFA entered against you, and that brings its own set of consequences. I'm certainly not advising any of you out there to go to a hearing or not go to a hearing, but just keep that in mind. Make sure you know exactly what it is that you are signing and what you are being asked to do before you do it. I think I'm going to stop here because this is already quite lengthy. And talk in a future video about how to actually handle a hearing, if you actually have to go to a PFA hearing in front of a judge. But I hope that this is helpful information for you, and that if you're finding yourself in this position where you are representing yourself because you don't have any other choice, because you were just evicted from your home and you've had to stay in a hotel, you have to stay in a hotel at least until the final hearing, and that costs money, and no attorneys are going to work with you for free or for a reduced rate. And you just can't come up with several $1,000s all at once at a moment's notice. That if you're finding yourself in that position, I hope that this at least gives you some grounding, so that you have a better sense of how to go into the final hearing and how to interact with the plaintiff's attorney. So I hope that this was helpful for you. I will make another video that focuses more on the actual hearing process and how to handle that. But for now, if you were just served with the PFA, please read that order, that temporary order, as carefully as you possibly can. And please make sure you read any kind of consent order, again, very, very carefully before you sign it. And if you are at all able to do so, I highly recommend that anybody who is served with a temporary PFA order, at a minimum, contact a local attorney and have a consultation about how to handle the PFA at the actual hearing. Thank you for watching. I hope this was helpful, and I will be back to talk more about the hearing itself. Until next time, take care.